In another video, I will leave the link in the iCards, kindly go through it, which is number 289, where I spoke about the two parts of a civil case. The first part is the trial, the second part is the execution. In this video, I am going to inform about the exception of the two parts, when there will be only one part in a civil case. One part in a civil case will be when you file a suit for injunction. Now, what is a suit for injunction? Injunction means, suit means case. Injunction means an order from the court when somebody trespasses or encroaches or dispossesses you from your property or disturbs your possession from your property. Then you file a suit for injunction. Whenever you file a suit for injunction, if you have documents in your favor, in your custody, original documents. If it is in bank also, there is no problem. They see it, it means that in the eye of the law, they are under your custody. You can apply a certified copy from sub-registrar. Within one day, you will get a temporary injunction based on those documents. If you approach a competent advocate, you must get it in one day. Because you are showing the prima facie case. There is no need to call the other side also. That injunction is called ex parte ad interim injunction. After protecting your right, notice will go to the other side. Then temporary injunction will be granted to you and it will be made absolute till the disposal of the suit. Now let us presume you got an injunction in your favor. You got an injunction decree in your favor. Now, unlike in a money recovery case, you have to go and attach his property, movable or immovable, or arrest him to recover your money. But here, in a suit for injunction, after obtaining a permanent injunction, now injunction is of two types, prohibitory and mandatory. Prohibitory means restraining the defendant from taking some action. Mandatory means compelling the defendant to do some action. Now, prohibitory is of generally temporary and permanent, and once suit is decided, it becomes permanent injunction for a lifetime. That is lifetime till you retain the property. So if defendant doesn't come and attack you, or defendant doesn't enter the premises, or defendant doesn't trespass, defendant doesn't disturb your possession, defendant doesn't encroach, then what is the need for execution of the order? Execution of the permanent injunction. So therefore, there will not be any second part of the case. There will be only the trial. There will not be any execution. Now here the interesting point comes. Court gave an order directing the defendant not to disturb the plaintiff. Now if the defendant comes again and trespasses into the property of the plaintiff, though decree is available, encroaches into the property, is it contempt of court? Or should you file a contempt petition under section 10 to 12 of Contempt Act? The answer is no. It is not a contempt case. We should not get confused because the law is already available for violating the order, violating the decree. That is under Order 21, Rule 32. Please remember this provision of law. When the suit is pending, if the defendant disturbs, provided there is a temporary injunction till the disposal of the suit, you have to file an application under Order 39, Rule 2A. If the suit is disposed in favor of the plaintiff, that is, you get a decree, you get an order from the court protecting your right that the defendant should not enter your premises for a lifetime, then you have to file an application under Order 21, Rule 32. You should not file a contempt case and waste your time. Though there is a court order, it doesn't come under contempt case. Now, if still the defendant comes and disturbs the possession of the plaintiff, that is, the defendant means after the decree he becomes a judgment debtor and the plaintiff becomes a decree holder. If the judgment debtor still violates the order of the court, still violates the decree, then an application must be filed under Order 21, Rule 32 for attachment of movable and immovable properties of the judgment debtor, or arrest him, or both. So that is a remedy available to the decree holder if the judgment debtor comes and disturbs the possession, trespasses or encroaches into the property of the plaintiff after getting the decree of permanent injunction. Hope I am clear. If you have any doubts, kindly ask in the comment section. Thank you. Thanks for watching.